Ms. Morris.
Good
Good to see you.
afternoon, Your Honors. Raven Priya Morris from the Appellate Division of the Public Defenders Conference. Here on behalf of the appellant, Mr.
Oh,
Gerald.
let's wait just a second. Can I ask that the parties exit the courtroom so we can proceed with argument?
I'm here on behalf of Mr. Gerald Elijah Crossley. Now reserve 4 minutes for rebuttal. We raised 3 issues in the briefs, 2 of which relate to the improperly admitted gang evidence and 1 sufficiency issue, based on the state's failure to prove identity to a degree of moral certainty. I plan to focus my time here today on the 2 gang-related issues, but I'm more than happy to answer any questions relating to sufficiency.
Before you specifically go through your issues, just so I get it, are you, in the first issue, are you finding fault in the gang testimony in general, and then your second issue is really the defendant's involvement or alleged involvement in a gang? Do I have that right?
I would just clarify a little bit. I think the case law made clear the way that I outlined the issues in this case distinguishes between the admission of evidence relating to an ongoing gang feud and then evidence of someone's alleged membership or affiliation because of the different rules of evidence underlying those 2 issues. So I have separated both of those, and that's how I intend to proceed.
I also want a point of clarification because I read it. Are you challenging whether the officer can be an expert in gang activity?
So trial counsel did not object to Investigator Robinson being able to testify as an expert, but I am disputing whether or not his expert testimony should have been admissible.
Okay. Okay.
So before we get into the issues, I want to start with some brief procedural history in this case. Prior to Mr. Crossley's first trial, his trial counsel raised a motion in limine seeking to exclude reference to any gang-related evidence. In response, the state asserted, and I quote, "The state has no objection to this portion of the motion and can agree that no gang evidence should be submitted to the jury as to the issue of guilt," end quote. Mr. Crossley's first trial on April 13, 2021 resulted in a hung jury. A month later, the state changed course, filing a motion seeking to admit gang-related evidence. Despite trial counsel's motion in opposition and repeated objections throughout the trial, the trial court allowed the state to present evidence of a gang feud and evidence of Mr. Crossley's alleged gang membership. No surprise, with the addition of this evidence, Mr. Crossley was convicted as charged, and that's what brings us here today. So starting with the first issue, the trial court erred in allowing Investigator Robinson to testify as a gang expert because his opinion was unreliable, lacked trustworthiness, and was irrelevant. So discussing the admissibility of expert testimony as discussed in Rules 702 and 703, expert opinion testimony must be disallowed when the underlying facts or data indicate a lack of trustworthiness. The state introduced Investigator Robinson's testimony to bolster its theory of the case that the shooting, in this case, was motivated by a rivalry between 2 gangs. Investigator Robinson testified about the rivaled history between the Ghost Mob Vice Lords and the Hoover Crips, going all the way back to 2013 in Jackson. Fast forward to July 23rd, 2019, 4 days before the shooting in this case, an unnamed Hoover Crip committed a drive-by shooting at Jacoby Snipes' house, a known Vice Lord. An hour or so later, the same day, 3 individuals, Jacoby Snipes, Charles Key, and John Farrell, known Vice Lords, all retaliated against the Hoover Crips by committing a drive-by shooting at a known Hoover Crip hangout. This was the last act of violence on July 23rd, 2019. Even still, Investigator Robinson concluded that the shooting in this case fit within the pattern of retaliatory violence between these 2 gangs. However, this opinion lacked trustworthiness and reliability because the underlying facts relied upon does not support this conclusion. So the pattern that Investigator Robinson testified to, where one gang would initiate violence and the other would retaliate against that, occurring close to a decade at the time of trial, would have been broken had the July 27 shooting in this case been a shooting against a Hoover Crip by a Ghost Mob Vice Lord. Because again, the Ghost Mob Vice Lords were the last to retaliate on July 23rd and therefore had no reason, no motive to double back.
Did he actually say that in the record, that somehow it's a perfect equation, 1 for 1? Did he say anything like that, or was it more general?
I think his exact testimony was that, or his exact opinion was that this shooting fit within the pattern of retaliatory violence between these two gangs.
So where does the proposition you're advancing come from, that somehow it's 1 and then retaliatory 1, and then it's over?
Right. I get that from Investigator Robinson's testimony. When he talked about the history between these two gangs, that is the pattern that he testified to. That was underlying his conclusion that he made into this case. He never testified to a time where there was any type of retaliation twice back or twice over, like what would have occurred in this case. I know it seems a little unusual, but that is the pattern that Investigator Robinson testified to, and we don't have anything supporting a reason why we would change or shift that pattern with the shooting in this case.
Was he asked that question at all?
I don't think so. I don't think he was asked that question specifically, but trial counsel did repeatedly object to
But I
the
guess-
reliability
I guess
of
maybe
the testimony.
And maybe even not asked. I mean, was there ever an argument made by defense counsel that, hey, look, you heard their expert say it's a 1 for 1, it's a 1 for 1, but now they want you to believe it's a 2 for 1. I mean, was that argument ever made?
I
If
don't
the
think-
question wasn't asked, I mean, did anybody try to point out what you're trying to point out now? Did anybody try to point out the issue there at any point in time in the trial?
Sure, I would say that this issue was definitely brought to the trial court's attention in the pretrial hearing on this issue. I can't say that trial counsel went into depth the way that I did about the 2 for 1 versus the 1 for 1 at trial, presenting that to the jury, but the trial court was surely made aware of the issue as far as the unfounded nature of this conclusion. So an expert may only testify if their testimony will substantially assist the trier of fact in understanding the evidence or determining a fact at issue. I just want to point out that motive is not an element of any offense, and Investigator Robinson admitted that his testimony did not establish the identity of the shooter. Investigator Robinson's testimony should have also been excluded because it was irrelevant. There's no connection between the rival gang violence and the shooting in this case. The two victims in this case were not affiliated with any gang.
Was it not the state's theory that the neighbor they had gone to visit was the actual gang member and they were really 2 innocent victims?
That's correct, Judge Wilson. So the state presented that the alleged target of this shooting was Levon Lake. He was a known Hoover Crip member associated with the truck the 2 victims were shot in. But Levon Lake was not connected in any way to the prior retaliatory violence that Investigator Robinson testified to. And he looked nothing like the deceased victim, Cole Felton. So that is really what makes the state's gang motive in this case so problematic. By the state's logic, anytime someone is merely associated with by actual association or mere proximity to someone known to be a vice lord or a Hoover Crip in Jackson, finds themselves to be the victim of a violent crime, it must be gang related. This cannot stand. This case is so much different from that of State v. Sims, where this court allowed the admissibility of an ongoing gang feud to support a state's gang motive for the shooting in that case. In that case, the state presented an expert who connected the perpetrator and the victims of the prior shootings going on between these 2 subsets of blood gangs to the defendant and to the victim. So there was a connection between the victims, the defendant, and the prior shootings that fit, I guess, the timeline, so to speak, that would allow a reasonable explanation that there would be a gang motive for the
Let
shooting.
me ask you
in that
this.
case.
I see some of the distinctions you're trying to make, but does this fall under Sims if the victims in this case weren't innocent bystanders, if they had actually been a member of the other gang?
If they were a member of the other gang, I think I would have a harder argument to make, but I think that's kind of but more than that, the issue with this case is not just simply membership in the gang, whether it be the defendant or the victims, it's the connection.
Right, but I mean,
between
you're
the
talking about two
membership.
gangs that are, at least according to the state's expert, retaliatory in nature, whether it's 1 for 1, 2 for 1, 3 for 2, whatever you want to say, they're retaliatory in nature. And so if he had shot and killed a member of the rival gang, seems like this proof from the police officer is relevant.
Well, we also,
And then, just because, I'm not trying to be flippant about this, just because he's a bad shot or somebody was unlucky as a bystander and got killed, doesn't change why the shots were fired, is my point. And so if that's the case, then this testimony still would be relevant. If it was relevant under Sims about the feud and the ongoing back and forth, why wouldn't it be relevant here? Just because someone who wasn't supposed to get shot got shot.
okay. So I will push back on that characterization just a little bit. And that's because in Sims, it was more than the victims were members of a opposing gang were targeted or harmed. It's also that the victims were connected to the retaliatory violence that the expert witness testified to. So not only do we not have any connection between the alleged target, assuming it was Levon Lake, to this prior retaliatory violence that occurred on July 23rd or any day before that, we also have no connection between Mr. Crossley and this prior retaliatory violence between these gangs. In Sims, there was a clear connection between the defendant, the victim, and the shootings that warranted the state's gang motive. in
What
that
about
case.
the older gang member that state alleged was directing the young folks to commit these crimes?
So I guess we have proof of Mr. Crossley's association with members of the gang, specifically Jermaine Tipler. Is that who you represent, the leader of the Ghost Mob Vice Lords? But even that association does not prove any connection to the shooting in this case. We don't have anything connecting Mr. Crossley to any shooting in this case, specifically to warrant that. Just his mere association with known members of the gang is not sufficient. If that's the case, anyone who was affiliated with or associated with the Ghost Mob Vice Lords would be just as likely to have committed this shooting. But we don't have a gang motive for this shooting.
But if the individual who's directing your client's actions, the older gang member who's directing your client's actions, we can prove he's got a connection to the prior violence, does that change the argument then? So I've got a connection to the prior violence. Me and some other person have been going back and forth at each other, and I come to you and say, I want you, because of what's going on with us, to shoot that person. Does that change the analysis then? Or is it still only you? I didn't have anything to do with it, so that doesn't apply.
Well, I mean, we don't even have that.
Okay.
Jermaine Tipler was the leader of the Ghost Mob Vice Lords, but he is not connected in any way to this prior retaliatory violence that Investigator Robinson testified to. Jermaine Tipler was simply implicated because Mr. Crossley was seen or present in a traffic stop with him, and that he had recently been released from prison, and things like that, of that nature. But there was no specific tying of him to the retaliatory violence that would have been primed on July 27th, 2019. So with the time I have remaining, I want to move on to the second issue relating to gang membership or affiliation. So first, the proper standard review of this issue is de novo, because the trial court did not substantially comply with the procedures laid out in Rule 404B. Specifically, the trial court did not find the prior bad act, specifically Mr. Crossley's alleged gang membership or affiliation, by clear and convincing evidence. And 2, the trial court did not conduct a balancing test to weigh the probative value of this evidence against the danger of unfair prejudice. The state agrees that the trial court did not make explicit findings on these 2 factors, and therefore this court should review it de novo.
Does it have to? Does it have to announce, I find by clear and convincing evidence?
I don't think that the trial court has to announce its finding in that way, but I don't think that there is enough in the record to find implicitly that the trial court substantially complied with Rule 404B here, because we have 2 procedures that were not complied with. So working through these 3 issues, 1, no material issue exists to warrant admission of Mr. Crossley's alleged gang membership. Again, the state's gang motive in this case is problematic because there's no connection between the shooting and the prior gang rivalry between these 2 gangs. Without a gang motive for this case, Mr. Crossley's alleged gang membership is absolutely irrelevant. There's also insufficient proof in the record to support a finding by clear and convincing evidence that Mr. Crossley is a member of the Ghost Mob Vice Lords. Investigator Robinson testified in a conclusory fashion about Mr. Crossley's membership. We don't have a gang validation form, social media photos, or any gang signs or tattoos or anything like that.
But you do have a video where he says, "I'm with them ghosties,"
All we have in the record is a video
taken on the day of the shooting.
taken on the day of the shooting where Mr. Crossley is wearing a shirt in remembrance of a deceased vice lord in his association with known members of the gang. But the importance of having this additional proof in the record, if I may
Yes,
respond.
yes.
Having this additional proof in the record is to allow the jury to evaluate the persuasiveness of the conclusion, and we just don't have that here. So even if this court is satisfied with the proof in the record to establish gang membership or affiliation, this evidence is highly prejudicial and warrants exclusion. As I stated, this case is much like that of State v. Hughes, but because I'm out of time, I'll just reserve that for rebuttal.
You still have your 4 minutes. Thank you, Ms.
Okay.
Priyan Morris.
Thank you.
Mr. Davis?
Good afternoon, Your Honors. May it please the Court, Ryan Davis on behalf of the state. This court should affirm the trial court's judgments for 3 reasons. First, the evidence was sufficient to support the jury's finding that the defendant was, in fact, the shooter. Second, the trial court properly exercised its discretion in allowing investigator Robinson to testify about relevant gang evidence. And third, the trial court properly exercised its discretion in admitting 404B evidence of the defendant's gang membership to show for the non-propensity purposes of motive, identity, and telling the complete story of the crime. I know that my friend has limited her argument to the first 2 issues, and setting aside the sufficiency, but I also think it would be helpful for some background. And so what we have in this case is a situation where the defendant was arrested in a traffic stop in possession of a gun and drugs alongside the leader of the Ghost Mob Vice Lords. The defendant goes to a juvenile detention center and he's outfitted with an ankle monitor. The ankle monitor is ill-fitting, doesn't work properly, and the defendant calls his girlfriend essentially asking for her to source a tool so he could get the monitor off. The defendant goes home and he is at his house on house arrest essentially for a while, and then he goes and on the morning of the shooting, the defendant makes a video with a well-known member of the Ghost Mob Vice Lords. In the video, the defendant, as Judge Wilson, you kind of pointed out, he has a shirt commemorating a deceased former Ghost Mob Vice Lord, a leader of the Ghost Mob Vice Lords. He has the murder weapon that he holds up, and he says that he's with them ghosties, and then his friend kind of talks about being a HK or a Hoover killer. And I think it's fair from viewing the video that the defendant is indicating his agreement with those statements. After that, several hours later, the victims here go to the house of Lavon Lake, who's a known Hoover Crip who lives just down the street from the defendant. The victims were going to borrow his white Chevy Tahoe and go to Memphis. They're sitting in the car. The passenger, the surviving victim, sees someone running up from the direction of the defendant's house, hears gunshots, rolls out, sees someone running back across the street, and then calls the police. The police get there. They take a K-9 to the defendant's house, find the gun in his backyard. The K-9 alerts at his door, and then the house is searched. Eventually, they find a black hoodie. They find the defendant has dark gym shorts, and then he is arrested and has gunshot residue on his hands. And then he lies a bunch to the police officers about his.
So with all of that, minus the gang affiliation, and that's some pretty damning evidence, the state couldn't get a conviction the first time they tried it.
Correct.
And the first time they tried it, oh, Your Honor, we don't need the gang stuff because we got some pretty damning evidence without it. And they couldn't get a conviction. And now all of a sudden, after they don't get a conviction, we need the gang stuff to complete the story. Isn't that just a backdoor to get in propensity to inflame the jury?
I don't think so, Your Honor. From what we could tell from the record, I don't think we have the closing arguments from the first trial, but we do have, the state's motion in limine where the state talks about what occurred at the first trial, and the defense counsel got up and argued, jury, we don't have any motive here, and therefore you got to acquit, and then the jury hung. And so, the state says, okay, well, we have evidence of motive because this was, by all accounts, a retaliatory gang shooting, and I'll get into that more in detail in a second. But the state has that evidence. It was going to hold it back at the first trial to be safe, and at the second trial, it's okay. Well, we can introduce this, and it's not a motive, identity, complete story of the crime. Those are not propensity purposes. And I understand Your Honor's point about being a backdoor, but those are well-established categories. And
Limiting instruction did the trial judge give on all this stuff?
it's on page 590 to 591 in the record, and we quote it in our brief. But the trial judge, so at the motion in limine hearing, the trial judge says, I'm going to let this evidence in, but there needs to be a limiting instruction, and the parties need to agree on it. And then we get to trial years later. The limiting instruction is given before any gang evidence is introduced. So it's given at like the perfect time. And the limiting instruction says essentially motive, motive, identity, and complete story of the crime. And that's it. Nothing else. If you consider it, those are the only three reasons. The state, during its closing argument, came back and said, motive. That's all we're trying to use this evidence to prove. I don't want you to use it for anything else. And so given the presumption that the juries follow instructions, that limiting instruction, the presence of it in the record is very strong. And so that's kind of like the background. And then as far as Investigator Robinson and his expert testimony and the relevance of it, Your Honors, this was a retaliatory gang shooting. Judge Wilson made the point about how, the defendant seems to be arguing this necessarily wasn't a one-for-one. I don't think Investigator Robertson limited his testimony in that way. I don't think he was asked if it was a one-for-one. And I think just looking at the facts of this case, targeting a gang member and then accidentally killing a non-gang member who's in the gang member's car in the driver's seat, that's well within the scope of Investigator Robertson's expertise, his knowledge, his understanding, and it's not an analytical leap. It's common sense. And so we believe that this gang evidence, as introduced by Investigator Robertson, that his expert testimony was relevant. And additionally, we have, this 404B issue. And first of all, on the standard of review, we believe it's abuse of discretion. And the trial court's ruling is in volume 2, 204 to 07. That's the written ruling. He also ruled from the bench. The trial court didn't use magic words, but given the evidence that the trial court recited, And what was presented at this hearing, this motion to eliminate hearing, including the video which was played, we know that the defendant said, "I'm with them ghosties" in the video, and that's clear and convincing evidence coupled with the shirt and the association with Tippler that he was a member of the Ghost Mob Vice Lords. And then as far as the weighing, once again, the trial court didn't use any magic words, but the trial court did discuss in its written ruling a limiting instruction. And so we know the trial court's thinking about unfair prejudice and, prejudicing the jury in a way. And so we believe, just given the written ruling, and where it cites 7 cases from this court, that the standard of review is abuse of discretion. Even if it's de novo, we still believe that the evidence was properly admitted. Once again, first, because, we have clear and convincing evidence, the video and the circumstances of this case. And then second, we have the gang evidence, which is extremely probative of motive. The defendant is he's claiming membership in this gang while holding the murder weapon. And his friend is talking about conducting a slide or a drive-by. And then as far as prejudicial effect on the jury, we have the limiting instruction.
So the 7 cases in the the court's order go to which one of those 3 prongs?
Your Honor, I believe that they kind of go to all of them in a way. So the court was citing cases that the case cited in its motion in limine, I believe. And so, Fritz talks about weighing the gang evidence under 404B. Creighton talks about 404B evidence going to show motive. Brewer talks about an ongoing dispute between 2 gangs. Mathis, just generally gang activities. James is substantial compliance. Hall is, motive again. And then we have Gardner, which is a pattern of retaliation between rival gangs.
So within the court citing those cases, similar cases perhaps, it's implicit in that it had already found by clear and convincing evidence. That's really what I'm
Sure.
asking.
And, the court lays out the testimony that the court heard. It talks about how it's excluding certain testimony. And then the court gets to those cases or notes that the cases have been cited and is relying on those cases. And the court agreed that the above evidence shall be admissible at trial, but only for the limited purposes argued by the state. Then gets into the limiting instruction. And so I think that the court is doing some weighing there. If this court disagrees once again, and the standard of review is de novo, we think that the trial court's admission of the evidence was proper. Pending further questions, we ask that you have.
Well, I've got one more. I don't have my notes here, but on that, the 404B evidence, was that where the state made the harmless error evidence? Harmless error analysis?
Where we made ours?
What,
Yes,
asking us to consider it as harmless error?
If this court thinks that the trial court erred, then.
Judge Dyer's question, it made a big difference.
Yes, sure, but once again, we have this limiting instruction. And so and I don't necessarily think we could look at the first trial. These are 2 different juries. I don't know if we can read the mind of the first jury, and then I don't know if we can read the mind of the second jury to know what exactly the trial court, or what exactly the jury was thinking of when it convicted, other than that the defendant committed these crimes and the evidence supported conviction beyond a reasonable doubt. And so we do maintain our position that if the trial court did err, then any error was harmless, especially relying on that limiting instruction. Pending further questions, we ask that you affirm. Thank you.
Thank you, Mr. Davis. Ms. Brian Morris, you have your 4 minutes.
I just want to start with prejudice under the 404B analysis. So just want to reiterate, even if this court is satisfied with the proof in the record establishing gang membership or affiliation, this evidence is highly prejudicial and should be excluded. Sims explained.
Counsel, let's be clear. The standard is not just prejudicial, it's unfairly prejudicial. All evidence against your clients can be prejudicial. How is this unfairly prejudicial?
Sure. So gang evidence inherently is greatly prejudicial in the issue of guilt in any case. I think it was State v. Sims that kind of really explained that point. Because the prejudice associated with gang-related evidence is finding someone guilty merely by their association with members known to have committed violent acts in the past, and that is exactly what happened in this case. Even though Investigator Robinson was unable to identify the shooter, and his testimony that this shooting fit within a pattern of retaliatory gang violence indicated that Mr. Crossley must have committed this shooting in conformity with his gang membership. So just last year, this court in Hughes disagreed with the trial court's determination that gang affiliation, a defendant's gang affiliation, was highly probative. I think that's kind of the common thread in this case and kind of overlaps with relevance. If we don't have any probative value for the gang-related evidence, it's also not relevant. But in Hughes, I quote, "There was no evidence whatsoever that the dispute between the victim and the co-defendant was gang-related." That's exactly what we have here, when again, the victim and the defendant is not connected in any way to the prior retaliatory gang violence. And Judge McMullen, I'm sure you're probably more familiar with the facts of Hughes than I am, but I think that the gang membership or affiliation in Hughes was incidental to the state's case. It was, I think, related to impeachment or something like that. So this court did find, even though it was error, that it was harmless because it wasn't stressed in the state's case in chief. We couldn't have more different facts here. The state's theory that there was a gang motive for the shooting in this case is the thread that held the state's case together from beginning to end. It is even how the state explained Mr. Crossley's ankle monitor alibi and the mistaken shooting is the gang evidence. Without this evidence, jurors in Mr. Crossley's first trial were unable to reach a unanimous decision, and the only difference between the first trial and the second is the addition of this gang evidence. So it undoubtedly affected the outcome, and it prejudiced Mr. Crossley from a fair trial. The trial court's limited instruction does not resolve the danger of unfair prejudice in this case because the trial court merely pointed the jury back to the state's problematic gang motive, and that does not resolve the danger of unfair prejudice. So with that, if there are no further questions, the preferred relief in this case is obviously for this court to vacate and dismiss all of the convictions against Mr. Crossley. But if that is not possible, we ask that this court reverse and remand for a new trial based on the improperly admitted gang evidence. Thank you.
Thank you, Ms. Breeden-Morris. Appreciate both parties' arguments and your briefs. The matter will be taken under advisement. Thank you, counsel. Call the next case.